Yes, I salute you all. Thanks for watching and thanks for being on. So basically, today we are going to look at contract law or the law of contracts. And basically today we are under the what you call the different kinds of what? Kinds of contracts basically. And when you look further or when you realize that contracts has various what? Have various categories to the same. And basically you have what they call express contracts, implied, void contracts, void and voidable contracts, then contingent contracts, which can be also known as conditional contracts basically. So first of all, we are going to look at what they call express contracts. For the layman's understanding, when you read section 9 subsection 2 of the Contracts Act, realize that defines what an express contract means. It is a contract that is expressed either by either orally or verbatively. It is orally or in writing. Basically, that is an express. Express is like you make it official, either writing or orally, but you have expressed the intention basically. Then when you go to what they call the implied contracts, those are contracts that are neither oral or written, nor written. You get just their conduct, the conduct of the person. They are the ones that show that really these parties had the intent to do what? To contract. That is under section 9, subsection 3 of the Contracts Act, portrays it very well. So note that in mind under implied contracts. Then when you go to void contracts can be also known as that they are void ab initio. You get, when you read section 2 of the Contracts Act, define what void contracts mean. An agreement that is not enforceable by law, that is a void contract basically. And what I have to emphasize, or what I look at, is that when you look at the void contracts, realize that those are contracts under mistake of law, mistake of fact, unlawful consideration of the object, lack of failure of consideration, agreement by way of wager, illegality, agreement to impossible act, among others. Those are some of the categories that make a contract void. Void ab initio, contract that is not enforceable by law. It is void at the face of it. So note that in mind. Then when you go further, realize that we have what they call voidable contracts. What do I mean by voidable contracts? Voidable contracts, for it, at the face of it, before even going further, at the face of it, they appear to be what? They appear to be good contracts, unless one of the party goes to court to claim otherwise. Section 2 of the Contracts Act define what a voidable contracts mean, which is to mean an agreement which is enforceable by law at the will of the parties to the contract. You get, here the contract can be enforceable by law, unlike void contracts. For example, under voidable contracts is that if you enter into a contract under misrepresentation or under by force or threats, realize that you'll make that contract voidable. It will be good at the face of it. But if you go to court and say that I entered in this contract out of threats and force, the court will declare it what? A nullity. It will declare it null. Reason being that it is enforceable by law, but at the will of all what? Of any of the parties to the contract. Some of the things that make the contract voidable, you have coercion, undue influence, fraud, misrepresentation. Following section, when you follow the Contracts Act, realize in contract 2 shall look under those. They are called vitiating factors of what? Of a contract. They make a contract voidable. So realize we shall look at it under contracts 2. So basically note that in mind, the difference between express and implied, void and voidable. Then we have what they call contingent contracts or conditional contracts. Contingent or conditional contracts, they are also defined under section 2 of the Contracts Act basically, which means annual contract to do something or not to do something, where an event is collateral to the what? To the contract does not happen. So basically here what they are trying to show, or what they are trying to claim, is that realize that under contingents, I'll use insurance contracts. Realize that if you enter into insurance contract with a company, realize that you won't receive anything unless the thing that you contracted has been damaged. That is what they call contingent or insurance or conditional contracts. Something must happen for the contract to be what? To be executed. failure for something to happen, then the contract cannot be executed. So those are the contingent contracts. So bear that in mind. The good example that I've given is that the insurance contracts. Basically, something must happen to the same to realize so that it can be executed. Then in supplement, there is what they call executed and executory contracts. What do they mean by executed and executory? Basically, what you have to bear in mind about executed and executory. Executed contracts, these are contracts that they are executed. The reasons why they say executed is that both parties to the contract have completely performed their obligations. That is executed. If it is to deliver maize, have delivered and have been paid, so that is a contract that is executed. Then executory is an exchange of a promise. I'll deliver, I'll pay when you deliver. That's executory. You hope to execute it in a mere future, basically. So note that in mind, or bear that in mind, basically. That's executed and executory. That's the difference between the two contracts. So bear that in mind. But other than that, these are the kinds of contracts that the day-to-day activities rotate from or pass by, and bear in mind that they are they are so essential in the contracts that in the day-to-day life, the contracts that we carry out. But thank you for listening and be blessed. Thank you very much.